TV's Close Up on Workplace Law, where we zoom in on recent developments of interest to employers, to their attorneys, and to their human resources professionals. I'm your host, Leigh Tyson, and I am a partner in Constangy's Atlanta office. So according to a recent statistic and a bunch of recent statistics that were just put out by the United States Department of Commerce, approximately 1 million Americans currently are employed in the financial and investment sector. So here to talk to us today is John MacDonald. And John is the head of our New Jersey office, and he has also been representing a number of financial clients all over New York City and the rest of the country. So we're very excited to have him here today to talk to us about this. John, welcome.
Thank you, Lee.
So, John, tell me, what makes employment in the financial sector unique?
It's different because it's regulated. The regulation stems from statutes passed during the Great Depression to protect the public and the industry as well. And those statutes and those regulations, in essence, control employment in the financial sector to this day.
Okay, well, what type of licensing is required?
Anyone who is in a production role, and what I mean by that is anyone who is in the sales or involved in the sales of securities is going to need licensing. That includes not only the direct producers, but also their managers.
Well, how does that make employment in the security industries different?
It makes it different because, in essence, there's a third party in the room for the employer and the employee. And that third party is regulation and the regulators. The employer can be subject to millions of dollars of fines if they get certain things wrong. Likewise, the employee can potentially suffer from being barred from the industry and lesser sanctions if they get it wrong. There are very few cases in the securities industry where potentially the regulators may have some impact, and as I said, the fines and penalties for both parties are significant.
So what's the most typical employment issue that you see in the securities industry?
The two most frequent are defamation and restrictive covenant.
As far as restrictive covenant, I'm assuming that's about the same thing as a non-solicitation agreement where you agree not to steal the clients and you agree not to steal the employees away.
Yes, that's exactly what it is. More so the customers and clients, because of course that's where the value for this type of employee really resides, is in their book of business.
Tell me why I should care about something called the U-5. I know U2, I don't know U5.
There's no bono involved in this. The U5 is merely the end of your employment. The key to the U5, which is a uniform, the U is for uniform, by the way. It's the uniform termination notice, and what's important about that is it lists for both purposes of the industry and the public and the employee the reason for the termination. And as you know, some terminations are voluntary and some are not voluntary. The reasons can go from, on the non-voluntaries, to lack of production, which is the most benign in some ways, to breaching company policy, which we're going up on the scale of less benign and more dangerous, to regulatory violation, which is very bad for the employee. It makes it difficult both as a question of regulation, because it may lead to the divisions of securities investigating you, for example. It also is bad for you because the next broker house, say, that you want to go to, or the next advisory company, they have access to that information. They will look at that U5, and they will decide whether that would bar you from employment with them. So as you can see, the stakes are significant.
And man, I smell a lawsuit already with that.
The employer has to get it right, and it's a delicate balance between what happened. And if you're the employer, you are obligated to write the bad stuff in if there is this bad information about that employee for the reason they're leaving. Because again, you're protecting the industry, and you're protecting the public.
Well, what about whistleblowers? Do brokers and other employees, do they get any relief from either Sarbanes-Oxley or Dodd-Frank? Do those help at all?
They do. They do in a more broad sense. They also apply to really anyone who works for a public company who is involved in the internal reporting structure of the company's financial information through upper management and out to the SEC.
It must be very difficult for one single human resources person or one single in-house counsel to be in charge of complying with all these different regulations. Is there usually one dedicated person in financial institutions who handles this sort of thing?
At least one. It requires someone with regulatory knowledge. You're going to need the traditional HR knowledge, because these companies, even the smallest ones, will have counsel. They obviously have compliance counsel, because you will need that at a very, very low level. You're going to need compliance counsel. And then as they build up in size, yes, they have entire departments dedicated to getting this stuff right.
All right, well, that's fascinating. I learned a lot today. This is really interesting stuff. John, thank you so much for joining us today.
Thanks, you're welcome. And on Dodd-Frank, of course, yeah, keep posted, because that statute may not be here fairly soon.
We've got to get this video posted pretty fast. All right, well, thank you guys all so much for joining us today. That's it for this edition of Close Up on Workplace Law. Thanks for tuning in, and hope to see you next time. Bye-bye.